Good evening. It is Monday, June 11th, and I welcome you to the Planning Board meeting. Before we get started, just a note, we are starting late at 6:15 due to some technical difficulties, but all of our members were here and ready to go. So why don't we start with our invocation, followed by our flag salute.
Please bow your head. Heavenly Father, we thank you for the opportunity to come together tonight. We pray that you will guide this meeting so that we can provide fair and respectful judgment for the issues before us in the city of Burbank. Amen.
Will you please join me in saluting our flag? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. May we have the roll call?
Yes, Chair Rosati. Board Member Liu?
Present.
Board Member Hadian?
Present.
Board Member Atikanian?
Present.
And Vice Chair Eaton?
Here.
And Chair Rosati.
I am here.
Let the record show all board members are present.
Do we have any announcements?
No, we do not.
Okay, so we have one hearing tonight, project number 16-0003542, development review for 2215 North Naomi Street. This is the time and place for hearing on the appeal of the Community Development Director's decision on project number 16-0003542 concerning an application for development review. The project proposes the construction of 4 residential apartment units on property located at 2215 North Naomi Street in the high-density residential R4 zone. The appellant to the Community Development Director's approval of the project is Jerry L. David Living Trust. Before we begin, do any planning board members have any legal or other conflict of interest relating to this hearing?
No.
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 No. Have any planning board members had any communications, including written, oral, with the applicant, or the appellants, the applicant's or the appellant's representative, or any other person?
No.
No.
No. No.
No. Mr. Ramirez, have the notices required by law been given?
Yes, they have.
Do we have a complete file of exhibits, correspondence, and other documents?
Yes, you do. With special note that 3 items were left in front of each one of the board members. An updated exhibit E1, page E1, which shows the appeal fee that was paid. Exhibit A was updated to note an update to condition of approval number 9, as well as a copy of the PowerPoint presentation.
Thank you. Are there any written communications on this matter?
All written communications have been included in your agenda packet.
Will the representative of the Community Development Department please introduce yourself and summarize the matter for us?
Good evening, members of the board. Good evening, members of the public. This is Danny V, Associate Planner with the City of Burbank Community Development Department. May I please have the presentation on the screen? Thank you. Before you tonight is an appeal application to a development review that was approved by the City of Burbank Community Development Director. The development review requests the approval for the construction of 4 residential apartment units on multifamily zoned property located at 2215 North Naomi Street. As you may know, the City of Burbank Municipal Code allows members of the public the opportunity of appealing a decision to the projects to the Planning Board. In this case, the Community Development Director's approval was again appealed before you tonight. When considering the appeal, the Planning Board must consider first whether the project can meet the findings required for approval per the Burbank Municipal Code, and second, the merit of the appeal. Having very briefly covered the appeal process, I'll move into talking points about the project. The development review is being proposed at 2215 North Naomi Street, property located close to the corner of Empire and Naomi Street, west of the Empire Center, behind an industrial commercial corridor, and in a high-density multifamily neighborhood that's adjacent to existing single-family zone properties. The property is located on the 22nd 100 block of Naomi Street on a property that is abutting an alley. The project is currently developed with a surface parking lot with approximately 27 parking spaces. This is an image of the existing property as seen from Naomi Street. In analyzing the development review request, staff looked at properties in the surrounding area to make sure that specific project features, for example, building height, roof style, and roof pitch, building orientation, and the location of entries and pedestrian access points were consistent with those that are seen in the surrounding neighborhood. These images are images of the surrounding residential neighborhood. You have two on this screen, and the next slide shows another two. As indicated in the staff report, the neighborhood is made up of, first, the mix of both multifamily and single-family type land uses that are single and multi-story with hip, gable, and flat roofs. Second, building layouts where parking is tucked away and is not visible from the front of the property, and also structures which orient the home's main entry towards the street. As previously referenced, the project proposes 4 residential apartment units. The 4 units would be provided within a 2-story structure that would provide 10 vehicle parking spaces, which would be accessed off the alley. There would be a total of 2 residential units per floor. Each unit would have a minimum of 50 square feet of private open space, would have access to common open area of approximately 600 square feet. These images show the proposed north-facing elevation, which would be facing the alley, and the south-facing elevation, which would face an adjacent multifamily zone property. And these images on this screen show the proposed front and rear-facing elevations. The apartment structure would be designed to include Mediterranean-style features and would feature the following characteristics: 2 stories, a hip roof, patios and/or balconies for each unit, and parking that would be tucked away and accessed off the alley. As indicated in the staff report, condition of approval number 9 would require that the applicant work with city staff during the building plan check process in order to get alternate finishes and design details in the front elevation that are more consistent with the proposed Mediterranean style of the apartment building. Also, as indicated in the staff report, planning staff requests that the planning board consider amending condition of approval number 9 so that it is inclusive of all elevations and not only the front. That way we can get 360 architecture around the building. As indicated in the staff report, it is staff's assessment that the project with associated conditions of approval can meet the findings required for approval for a development review. These findings include that the project is consistent with all applicable provisions of the Burbank Municipal Code, and that the project complies with the neighborhood character and compatibility requirements in section 10-1-631 of the Burbank Municipal Code. Subsequent to the director's approval of the development review on January 26, 2018, the project was appealed, and it is now before you tonight. The project was appealed on the basis that the approval of the project would remove an existing parking lot, which would be in conflict with previous city approvals and requirements issued to 2215 North Naomi Street. As part of the appeal, the appellant states that the parking lot at 2215 North Naomi Street needs to be made explicitly available to the property at 2701 through 2707 West Empire Avenue. For reference, here's an image showing the property at 2215 North Naomi Street in relation to the property at 2701 through 2707 West Empire Avenue. The properties are separated by an alley. In blue is 2701 through 2707 West Empire, and in yellow is the property on Naomi. In order to better understand a past relation of the properties, I'm going to briefly go over some background information. In 1991, both properties, 2215 North Naomi Street and 2701 through 2707 West Empire Avenue, were sold as a group of properties by the former Burbank Redevelopment Agency to a common owner. When selling these properties, the Burbank Redevelopment Agency anticipated the properties would be redeveloped together within 36 months of the sale date. However, there was no requirement in the land sale agreement that specifically tied any parking at 2215 North Naomi Street to any other property. Additionally, in 1992, a CUP was issued with approval, which allowed for a parking lot at 2215 North Naomi Street. The parking lot was intended to provide parking for the anticipated redevelopment. However, there was no requirement in the CUP conditions of approval that specifically tied the parking lot to any other property. Subsequent to the sale of the properties in 1991 and the issuance of the CUP in 1992, the anticipated redevelopment of the properties did not occur. In 2002, a piece of the properties was sold off to a different owner. The piece sold off was 2701 through 2707 West Empire Avenue. Again, here's a map for reference. The piece that was sold off to a different property owner is the property in blue. The current owner of these properties is the appellant before you tonight, and he has appealed the project. After staff review of the administrative record, which includes previous city approvals, all covenants, conditions, and restrictions on the properties, the land sale agreement, and building permit records, we disagree with the appellant's statement that the parking lot at 2215 North Naomi Street needs to be made explicitly available to the property at 2701 through 2707 West Empire Avenue, given that we have found no records or documentation that explicitly require that the service parking lot at 2215 North Naomi Street make parking available to 2701 through 2707 West Empire Avenue. In summary, it is staff's analysis that the findings of fact can be made to approve the development review as proposed, subject to the associated conditions of approval, whether or not the planning board reaches consensus to amend condition of approval number 9 per staff direction, and that the redevelopment of the existing parking lot as a multifamily project would be in conflict with previous city approvals issued to this project site. Based on staff's analysis, as noted on the staff report and resolution, staff recommended the planning board approve a resolution of the planning board of the city of Burbank denying an appeal to the community development director's approval of the project number 16-0003542 that would allow for the construction of 4 residential apartment units, thus approving the project. This concludes staff presentation. I'm available should there be any questions. Thank you.
Thank you, Ms. Vega. I would invite the appellant or their representative to address the planning board. You'll have a maximum time of 15 minutes to make your presentation.
Good evening, everyone. Thank you for your time. My name is Elia Thompson, land use attorney at Irvin, Cohen, and Jessup. I'm here representing the owner, Mr. Jerry David, and the Jerry David Living Trust. He's sitting here, as well as the property owner's longtime representative, Rick Abramson. So we reviewed the staff report, and the staff seems to be basing their entire argument on the inability to find records that explicitly require that the Naomi lot be made available to the Empire buildings. But I want to point out a number of things. You have our letter. I'm not going to read the letter out loud, but you have our letter and you have all of the exhibits. So I'm just going to take some bullet points. If anyone thinks I'm talking too fast or you don't know where I'm getting this from, ask me, because I have the exhibits written down here. On November 7th, 1991, the application for the CUP to allow the construction of a parking lot explicitly called out the proposed use of premises as a parking lot for 2701-2707 Empire Avenue. In December 3rd, 1991, Burbank Redevelopment Director's memo from Robert Tague, who was then the executive director to Bud Overham, Mr. Teague outlined the history and explicitly stated in that memo that the Naomi property was intended to be used for parking to serve the 3 M2 properties on Empire. In the commercial development memo dated January 6, 1991 to City Planning Board, staff requested authorization to develop the vacant property at 2215 into a surface lot, explicitly stating that the reason being was in order to facilitate development on Empire Avenue. Further, staff stated explicitly that the board's approval would grant the city the ability to assure prospective buyers the use of the project site as a parking lot. At the Planning Board's January 13, 1992 hearing, the board explicitly granted a CUP to develop an off-street parking facility at 2215 Naomi. There was a covenant in 1995 or so to hold all the lots as one parcel. And later on, there was a second covenant that did not receive city's approval, even though it was explicitly stated in all the approvals that in order to change that covenant, it would need city approval, that simply took Naomi out of that covenant to hold all the parcels. In 2008, while attempting to process the same applicants' then request for an amendment to the CUP and add a variance to remove the required parking spaces for the Empire properties, that was their specific request, remove the required parking spaces for the Empire properties. City staff repeatedly stated, and this is Exhibit J, should the request for a CUP amendment be approved, it appears the Empire properties would no longer meet their parking requirements. Staff further stated, and please, I direct you to the Exhibit J so you can see your own staff's words and not take them as mine, but they specifically stated, the best case to present to Planning Board would be to show that there is a plan for the existing commercial buildings to meet code, not to demonstrate that you are putting a property in violation, which is exactly what they are doing today. So I go back and direct your attention to just a couple more items. Back in 1990, 1991, the city prepared an RFP for developers that would who would redevelop the two Empire buildings with the parking lot to be used for this redevelopment. The property was sold at a loss of $145,000 because city, quote, had confidence that the developer had demonstrated an ability to complete construction projects and had the resources to complete development on this property, and therefore would carry through the goals of the redevelopment for Empire. The city explicitly required the developer to surface the lot as a condition of the CUP so that the Empire buildings would have adequate code required parking. I won't go through all the history, but there is a history of illegal, unpermitted code violations on the Naomi parcel. The city has gone back and forth. But I do bring your attention to the memos from Joy Forbes, who was the previous deputy city planner. On December 5th in 2008, she wrote to the applicant of the Naomi property and advised them that currently the properties on Empire are meeting parking requirements with the Naomi lot, and should your request for a CUP amendment be approved, it appears they would no longer meet their parking requirements. The best case to present would be to show that there is a plan. In 2009, the applicant requested to amend the CUP and applied for a variance to untie the property. In their application, the applicant explicitly stated that Naomi is to be used as an off-street parking facility for Empire. That's what they stated in their own application in 2009. In that same document, the applicant acknowledged that the city does not believe that the number of parking spaces at Empire meets current code requirements. Therefore, in order to allow the request for amendment, the city is requiring us to seek a variance on your behalf so that your property is exempted from those code requirements. This was back and forth documentation that the city told the applicant at the time, you have to get their permission. This applicant has waited almost 10 years, has reapplied several times, this time not for parking, for other commercial buildings in the area, which, by the way, I do encourage you to look at the slide that did show the properties, because you will see that every lot behind the Empire buildings that crosses over the alley, they're all parking lots. They're all parking lots to be used for the Empire Avenue properties, all up and down in their Empire Avenue. There's 6, 7 lots back and forth. So in terms of being consistent in conformance, the parking lot is consistent in conformance with what is all along there for several blocks. So I leave you with this. If the city decides to deny the appeal, you're sending a strong message that it doesn't matter what deal you make, what restrictions are placed on your property, what the intent of the decision makers was at any particular time, what conditions to which the property owner agreed to at the time but had no intention with which to comply. If a property owner can just ignore requirements and wait long enough, staff gets replaced, memories fade, city politics change, and eventually the property owner gets what they want. Now, I leave this with you as food for thought in terms of where do we go from here? What's a possible compromise? Because again, we're not anti-development. We don't want to not see people be able to develop their property. However, my client's property rights do need to be respected. So I leave you with this. By approving this application, the city is causing great harm to the owner of the Empire properties, because they will never be able to fully use their property based on current code requirements. They have 10 parking spaces for roughly 9,000 or so square feet of space. And so with this, what we would like is that if the use of the parking is permanently stripped from my client, then we ask that the city make a determination tonight that the property, the Empire property, is fully compliant with all uses in the current zone with the current 10 parking space configuration. Because that's in essence what you're telling us. You don't need this parking lot, we're going to take it and create housing. If that's the case, then we need some sort of grandfathered in rights or existing non-conforming rights that, as long as we're doing a use within the zone, not changing zones or not going through any kind of major entitlement, we're utilizing use allowed in the current zone, that the 10 parking spaces meets the city's parking requirements. Thank you so much for your time.
Thank you. Before we open up the hearing to the public, I would invite the applicant or their representative to address the planning board. You will have a maximum time of 15 minutes to make your presentation.
Yes, my name is Mel Burney, and I own the property with the parking lot. I've been in Burbank for 42 years with different buildings. Some of the things that were just said, I think, are incorrect. There happens to be 14 spaces on that property. Unfortunately, they're using 4 of them for a lunchroom. And there's not 9,000 square feet, at least not when I owned it. There was about 6,500 square feet. So I'm not sure where this new size grew over the years. But as far as parking, the building was sold to Bond Boot, I believe, in 2002. They did not want the parking. They didn't want to buy the additional parking lot. So at that point, I believe, is when we split it. And they had no problems with the amount of parking they had. In fact, they had more than they needed. So the lot has been used for many different purposes. One, when we have an overflow of cars for the Kids Castle building, which I believe, while it was Kids Castle, it was needed. It's the building right next to the park there. Since they've closed down, it wasn't necessary. So, and since our business is downsized also, we're not thinking that we're going to need the overflow any longer. And that is one of the reasons why we've decided to build the apartment house. Other than that, it's nothing more to be said.
Thank you. We will now open up the public hearing to hear from any persons in the audience who wish to speak on this matter. Each person may address the planning board for a maximum time of 5 minutes. Seeing none, would the representative of the Community Development Department like to make any further comments?
Yes, thank you, board member. So I would like to clarify a couple things. The appellant did mention that I would like to clarify, post the appellant's comments, that when city staff looked at all the administrative record, when we looked at all the documents on file, and that included, again, conditions or the CCNRs on the property, building permit records, entitlements on the property, the land sale agreement, we could not find anything that tied these properties together. There may have been an intent in the land sale agreement that when the property redeveloped, there could be parking available made at this site, but that was not necessarily a requirement. Beyond that, in the CUP that was approved in '92, again, it was not a requirement that parking be made available for the properties on Empire on this property in Naomi. It's common through conditions of approval to have those kind of restrictions. As you know, you've considered items in the past. And if that is something that is a requirement that is imposed by the board at that time, that would be a condition of approval. In many cases as well, whenever there is ties to properties, in this case parking ties, there is on the title records something to that effect, stating that there is property A tied to property B for parking purposes. Talking to that, the appellant did mention that in 1995, there was a covenant which tied properties together. This is Exhibit E29 in your report. In 1995, the appellant is correct. There was a tie on the properties which tied the Empire properties to this 22215 North Naomi for building purposes. What that means, if you read through that covenant, it's very common for the building division to allow properties to cross property lines through this type of covenant to forego having to go through a process through where you put fire resistive walls in that building that would otherwise not be required. That could be costly. That could be in many cases something that's not functional. So because of that, there is that option. If you look at Exhibit E32, in 2002, there was a covenant which specifically omitted that property, 2215 North Naomi, which is referenced as Lot 41 from that covenant. And to the appellant's comment, it was approved by the city. If you look at sheet E32, the building official signed it, and then below that, there's a city attorney's signature, which
that
also—
That would be page E33.
Thank you, city attorney. E33, there is signature from both the building city official and from the city attorney's office, again, stating that the city at that time is okay with this covenant. Moving beyond that, we do understand as current city staff that there was a decision made in 2008 by previous city staff to the effect that stated that the properties were in some way linked together or tied. Current day, we have to look at the administrative record again and process this application as an application that we're considering right now. We could not find anything. Having worked on trying to on reviewing these records for months. As you know, the original decision by city staff was scheduled for 2017, beginning of the year. Now we're in 2018. So in that time, we looked and tried to find if there was anything, and we couldn't, again, find anything to the effect that tied these properties together. So while city staff in 2008 made that determination or that statement, we current day could not confirm that that was correct. Additionally, moving beyond that, there was a request from the appellant today that if the planning board does approve this project, denying the appeal, that the properties on Empire be deemed parking compliant to all users allowed on that site. I just want to make the board aware that that would be in essence granting a variance. And you do have to be aware that when granting a variance, there is findings that have to be made. And moving beyond that, a variance, as you well know from having considered others in the past, do have to show circumstances that go beyond what other people or what is a norm, in essence, to deem the granting or the approval of that variance justified. In this case, as you know, as you may know, and as I know from dealing with a number of members of the public who are trying to move into properties, parking is an issue along our major corridors. It's very difficult to get restaurants in our major corridors because of the parking requirements. It's very difficult to get medical offices along our major corridors, including Burbank, Magnolia, including Empire, including Olive, because parking is a problem. Granting a variance to allow parking to be waived, in essence, for this property would be, again, something that may go beyond what could be approved through a variance because, like I mentioned, it is something that hinders several properties in Burbank, a number of properties in Burbank beyond just this one. It wouldn't necessarily be a unique case. I would like to mention to the appellant that in our code, in the Burbank Municipal Code, should someone want to pursue a use like a restaurant, there is a process they can go through called an administrative use permit. If that restaurant is less than 2,000 square feet in size, city staff can look at the surrounding area to see if there's enough on-street parking to potentially justify the approval of an administrative use permit to allow for a restaurant on that site. But beyond that, again, I would say that just to make it clear, you would be granting a variance should you proceed with that request that they made. We have no further comments at this time. Thank you.
Thank you.
Mr. Chair, if I could add just a few comments. First, the conditional use permit. The applicant for the conditional use permit was the redevelopment agency. And the approval of the conditional use permit was actually grounds for the purchaser to terminate if it wasn't granted. So it was kind of a condition of escrow. The agency offered that up, not the applicant. As Mr. Villa indicated, the city has many circumstances under which it requires covenants between parties for parking. As he indicated, we searched, no such covenant exists. And the two covenants are that both the appellant and Mr. Villa referred to are expressly for omitting fire-resistive wall construction, not for any type of parking purpose. So our inquiry was to determine whether the city had any restrictions. No restrictions were imposed in the first place, and no restrictions have been required. And in reviewing the covenants, it does not appear improper that in 2002, a parcel with no building would be excluded from a covenant addressing fire-resistive wall construction. And then with regard to the requested advisory opinion on the non-conforming nature of the Empire property, first and foremost, it's not agendized for consideration. Secondly, we don't issue advisory opinions on the conformity of properties unless there's an application pending for some use. So that wouldn't obviously be appropriate in a hearing for the Naomi property.
Thank you. Does the appellant or their representative wish to make any further comments? You will have a maximum time of 10 minutes.
Great. So a couple things. First of all, my client has tried to buy the parking lot parcel many, many times. He's reached out to the owner, reached out to the owner's rep, has tried to work out a deal, work out ability to pay for the parking. It was fenced in and padlocked several years ago, and numerous attempts to reach out to the client's rep has met with stonewalling and no response whatsoever. I do want to say that we did a public records request, and when we got it back, there was a pretty voluminous amount of documents. So we're still, we've gone through all of them, but we noticed today that there was a letter from the Burbank Redevelopment Agency. Unfortunately, I only have the one copy from my binder, but I'll pass it through. But I did want to just comment on the fact, because we found a ton of documents relating to this purchase in 1991, 1992, and the clear intent of the CRA. And specifically in this memo from the Burbank Redevelopment Agency, November 1st, 1991, it specifically says that the agency anticipates the parcel fronting on Empire Avenue will be developed with a use compatible with the M2 zone, and that the parcel at 2215 Naomi Street will be developed as parking to support the development on Empire. In order to be used for parking, Naomi Street will require a conditional use permit, which is what they went after. It's nothing to do with a fire block wall. The proposed parking lot on the subject site is compatible with existing uses in the area. There are 5 parking lots in the 6-block area on either side to the east and west of the subject property. Again, this is the 1991 letter. I apologize, we're still, I mean, the amount of documents was pretty voluminous. But I also want to just say, there's a little irony here in that we put forth the idea, and not really, I want to circumvent your planning approval process. I get that. I just wanted to put it in your minds that basically by taking this action, you're now going to create an existing non-conforming, well, you're going to create a parcel that doesn't have the proper parking. So if we're not existing non-conforming, then right away that those properties are now in violation. And it's interesting that the comments made by the planner, and I don't think he's wrong in terms of the variance procedure, but that's exactly what your own staff was telling this gentleman in 2008, 2009. You can't do your development unless there is a variance that allows the Empire property to no longer have access to the parking, and that you need to have their signatures on this, and there needs to be a variance along with your application for development, which we agree with, exactly what your planner said today. And that's where we like the city's focus to be in terms of how do you do this without robbing from Peter to pay Paul, if you will. Because if you take this action, the existing uses on the parcel on Empire will be in jeopardy, and it means that they can never develop this property with allowed uses, you know, in the existing zone today. So again, I just really want you to caution you that by taking this action in a way where we're not doing it in conjunction with an overarching project that involves both parcels, it's going to be very damaging to my client. And with that, I thank everybody for their time.
Thank you. Does the applicant or the representative wish to make any further comments?
When I sold the property in 2002 to Bond Boot, and I guess 6 years later, they turned around and sold it to the next person, which is who there's in this building now. He knew what he was buying and what the property was. There was no secrets about it. Bond Boot owned what they owned. So there shouldn't have been any anticipation that something more was coming. And as far as anybody ever trying to contact us to lease the parking lot or to rent it, we've rented it many a times. We're available around the clock. And if they have something in writing that they've ever tried to contact us, we've never seen it. And this lady sitting over here, Maribel Pacheco, is the one that handles all the real estate, and she's never been contacted.
Thanks. Does the planning board have any questions for staff, the appellant, or the applicant? I have a lot of questions. Let's start with the appellant.
I'm going to ask that Rick join me because he knows the history of this, and then you may have questions that I can't necessarily answer.
How important is this parking lot to your client and what their goals were to develop this property?
It's been incredibly important all along, and like I said, we're in a public forum. I want to be respectful, but it's just not true. I mean, my client has reached out to them over and over and over again to find a way. I mean, again, they don't think that they have a right to this parking lot for free. I mean, obviously there has to be some sort of, some sort of agreement, some sort of contract done. But they have tried numerous times, and they have offered to buy it several times.
And I think you just answered that question very clearly. If this property was so important to your client's purpose of developing, why in the world didn't they make it part of the purchase agreement when they purchased Empire? Why wasn't there a negotiation, some kind of purchase agreement or stipulation that the lot went along with it? I mean, I can't understand why umpteen years later you would come back, and you just said yourself, they never felt entitled to this property.
No. I said they did not feel that they should be given free parking for this. But that, I mean, there was, when they bought it, my understanding, and Rick can correct me, but when they bought it, they thought that they were buying a parcel that had some tie to Naomi to where they would be able to rent parking on a monthly basis, yearly basis, something along those lines.
How was this transaction written up? Was it written through an attorney? Was it written through a real estate agent? How was this? How was the purchase consummated?
We don't have any knowledge of that.
Yeah. The applicant's right there.
Through a realtor.
Okay. So you had a formal process to purchase. He was represented by a realtor to purchase this property and never thought to include the parking lot in the sale. Correct?
Well, the title report contained language that talked about the rights and privileges that run with the land. There was plenty of documentation that talked about that parking.
You got to talk into the mic.
Yeah. That there was in the title report and the deed, it referred specifically to the redevelopment plan and the rights and privileges that went with it. And so there was a clear intent that that parking was set aside. The city purchased the land and demolished housing on this property. There was housing on this property. The city demolished it and created a parking lot. And it was part of their vision through the redevelopment agency to have a vibrant Empire. And so there was never a thought that that parking wouldn't be available for Empire. All the documents were so clear.
I understand, but this is what I do for a living. And if I'm going to protect my client, I don't care what the title report says. I'm writing in that purchase agreement that I'm getting that lot for my client, or I'm at least covering my client and myself in the event of some failure as to what we're discussing. And you brought up another point that I was going to ask. What was on that lot prior to it being a lot? It was a building. It wasn't parking for Empire.
No, the building was there in 1991. They were even 1990. They demolished housing.
I understand. What I'm trying to point out was the Empire property that you were here talking about, that wasn't the original parking lot for that property. There was something else on that lot, and the redevelopment agency asked for, correct me if I'm wrong, for it to be demolished and for the plan of the redevelopment agency and their goals. But then that went defunct, and then it got sold and everything, correct?
No. The Empire buildings existed, and the city realized that they would never be vibrant and redeveloped without the parking, so the city took the action to purchase Naomi and create the parking, and all the documents talk about for Empire to survive, it needed the parking. That's why the city took the action.
With a bigger picture in mind, but originally the Empire property did not have a parking lot behind it, as it was suggested that all the parking, all the businesses along Empire have parking behind it. There was never parking behind it originally. There was a building that was demolished.
Right. There was a little bit of parking behind 2707, and then there was parking along 2701. So there was a little bit of parking, but the city understood it didn't conform with the code, and so therefore they took the action to purchase Naomi. That was why. Why else would they buy housing and tear it down and build a parking lot? That wouldn't make sense. Why would the city take that action?
Okay. I have more questions, but I'm going to let my other board members.
I have a question. Planning department representative.
Yes, board member.
During these conversations, was there any discussion between the planning department and the appellant regarding the situation that would be created, as far as in their minds there's this, at this point they comply with the code, meaning there's sufficient parking, which kind of lends me to believe that somehow that additional parking is calculated or attributed to the Empire property, and absent of that parking would kind of put them in a non-compliant position. So when I reviewed, I want to give somewhat of a background. When I started reviewing all these documents, it was almost like a two-track type of a thing. To me, there's some underlying property rights issues that I don't believe I have all the documents, to tell you the truth, and I think the appellant even admitted to it that they've received a great deal of documents that they haven't gone through yet or presented. So I'm kind of at a loss as to how we're supposed to evaluate something absent documents, and some of them could be extremely important. But nevertheless, if there's this issue that the Empire property now, after this project has been approved, would be non-compliant, how is it compliant now if they don't have a right to parking on Naomi?
To that point, planning board member, you are kind of hitting the nail on the head with that. Because this parking currently is not tied to the properties along Empire, the properties on Empire right now are not dependent on it. If this parking goes away, they would not be more non-conforming than they already are. Right now, like many other properties in Burbank, they're along a commercial corridor, and they're non-conforming because they don't have enough parking to be able to justify the uses on that property. However, like other uses along commercial corridors in the city of Burbank, by policy, they are grandfathered in for up to a parking demand of 3.3 per thousand. What that means is that they could have office uses. They could have, if allowed in that zone, potentially retail uses. They could have M2 appropriate uses like warehouses, post-production, things to that nature, to that effect. However, to answer your question directly, like I mentioned, they would not be more non-conforming than they already are, because currently that parking is not looked as required parking for Empire, because there is no legal tie.
So the only time this issue would come up if there was some sort of a development proposed on the Empire property, then the parking situation would be looked at to determine if there was sufficient parking to approve the proposed development.
You are correct, and I would like to add to that, it would also be looked at to say if they wanted to have a use go in there that requires a higher parking demand than 3.3 per thousand. For example, restaurant is a prime example. A restaurant would require a parking requirement of 10 spaces per 1,000. That would not be allowed on that zone in lieu of complying with parking. Another example, for example, CrossFit studios, gyms, things like that, those would not be allowed on that property without sufficient parking.
So in essence, it restricts the type of tenants that property may entertain because of the parking or the lack thereof.
You are correct, and I will add this. Like I mentioned earlier, it is something that's common across commercial corridors in Burbank. For example, Magnolia Park is a prime example. So we understand that there is a concern and there is a hindrance on properties when they don't comply with parking. The way our code reads right now, maybe it's a larger policy discussion to have with planning staff and city council as to maybe we should look at policy matters, that as a policy matter, maybe allowing for other uses, maybe through a parking district. I know right now it's something that we're looking at, again, through city council. But you are correct, planning board member.
If I could clarify, no one has made any determination that this business is non-compliant. So it would really depend upon what use, whether it's 9 or whether it's 14. no one's reviewed that. So as you indicated, board member, it wouldn't be until they applied for a change of use that that determination would be made.
Okay. Board Member Liu.
Thank you, Daniel, for the report. I appreciate the information. Can you just explain to me again this December 5th, 2008 letter from the city of Burbank basically stating that this is tied together? Was that just an error, that they just didn't have the information? They didn't see in 2002 something was disconnected?
No, thank you for bringing that up. So to clarify that, the appellant is correct. There was a letter, and it is in your exhibit, that at the time our community development director made a determination that the properties were in some way linked together for parking purposes. I will call it that, an error at that time, I would say. There is no documentation as to how they reached that conclusion. And looking past that, current day staff has looked at the administrative record, which, as Mr. Planning Board member at the union mentioned, does include other documents, but we did provide you the relevant documents to the land sale, to what's being discussed tonight. And in these documents that we reviewed, there was nothing tying them together. I will say this, I don't think it's appropriate to make a mistake twice. And with that being said, again, we do believe that it was an error on staff's end in 2008.
One more question. So in regards, because when I'm looking at that area, that first line, as was properties, as Ms. Thompson did mention, are all parking lots. Is this, I mean, does this open up the fact that they're going to basically, the parking lot owner is going to be developing all of those, or like how does this fit into the existing planning?
Understood. If I may please have a presentation, I'd just like to pull up an area so we can look at what the appellant's representative referenced. So let me just filter through this and make my way to the zoning.
If I could, some of those properties have covenants on them. The Kids Castle, when they came in, we had to update all the covenants so that they could show sufficient off-site parking. So some of them have covenants, some of them do not. The purpose of the conditional use permit is to allow parking adjacent to residential. So the staff report, the redevelopment agency staff report indicated that. You can't do a parking lot in a residential zone without one. Another important point is that a conditional use permit is a right that can be revoked. And on the face of the conditional use permit, had they not used it, it would have expired. So it was not a requirement that was enduring. And our municipal code also says, section 10-1-1951 says your conditional use permit will terminate if you abandon it or don't use it. So there's a possibility that chaining up a parking lot in a residential zone for 10 years could be evidence of abandonment, in which case there could be no right to conduct that use on a residential property.
Thank you, Mr. City Attorney. And Ms. Liu, going back to part of your question, if I could have the PowerPoint up again, please, the presentation. So if you look at the area, you'll see with a star the project site, which is 2215 North Naomi. If you look at what's around it, there's residential. The property directly adjacent to it is R4. The one behind it is R4. And like you mentioned, there is some properties along that strip of the alley that do have parking lots. I will say that the overall vision of the city, and this is stated in our general plan of Burbank 2035, is to see these properties redeveloped to be residential, specifically high-density residential. So it is within, again, the vision of the city to eventually have these redevelop into residential-type uses, including this property.
And just if I can add one thing, the other thing to keep in mind too is that at the point that dissolution of the redevelopment agencies, and I don't know. City Attorney may be able to further expound. The former redevelopment agency, pretty much the effect of that created the successor agency, and their responsibility really was to phase or wind down the process of the redevelopment agency. So whatever the intent of the redevelopment agency was, I think most recently we did our general plan update in 2012. There's been action since then that have further cemented what the associate planner is noting, is that The long-term vision, as was alluded to, was to see redevelopment on Empire, but then also allow for housing and higher density housing on this property that's currently in front of you for consideration tonight.
So I just want to read something real quick. It's G24. The site will be conveyed in an as-is condition, and the buyers will occupy the existing buildings and temporarily pave the vacant portion of the site for parking purposes. As a condition of the sale, the buyer will use the property in its existing state for a period of 30, not to exceed 30 months, after which the site will be redeveloped in accordance with the agency standards. Did that ever happen? Was it redeveloped according to the agency standards?
No, it wasn't, planning board member.
And what is it? Does that mean it's abandoned and the agreement is no longer valid?
So the redevelopment agency did have, as a contingency, that should the redevelopment not occur, the redevelopment agency had the option of buying the property back. They did not exercise that option.
Okay. Any other questions?
I have a question for staff. Okay. So I have a question about the original conditional use permit. Let's go before that CUP. There were 5 legal lots, 4 APNs that were bundled and sold to a private party. In the meantime, they filed the CUP to have to waive the construction of the firewall between the only two buildings, correct?
You are correct. The land sale, so there was a land sale agreement before the CUP that sold the compiled properties together to the owner. The owner, upon that sale, had a contingency in the sale that they could opt out of the sale agreement should the CUP not be approved.
Right. So so a redevelopment agency, before even putting the properties for sale, had filed the CUP, and then they sell to private party, with the condition that this CUP has to be included as a part of this sale, right? The recorded CUP.
I'm not sure when the redevelopment agency filed the CUP with the city, but you are correct in stating that the sale did happen, and then after that, the CUP was approved.
So in January 6th, the dates I have, January 6, 1991, CUP 91-43 was filed. And then December 91, city sold the properties, all of them. And the properties are 4 APNs, 3 on Empire, 1 on Naomi. That the 3 APNs has 4 legal lots, as mentioned here, 37, 38, 39, and 40. 37 and 38 are tied.
You are correct.
Which makes 1 APN. So 3 APNs, 4 lots, 4 legal lots, and 1 APN on the street, side street. And then by February 92, the CUP is final. Then in 95, the covenant 95-18-12259 connects these two buildings as having one owner, but not legally. They just want to make sure that the properties have one owner.
The purpose of the covenant to hold them as one was to get around fire code upgrades. They had to be one owner to execute the covenant, and the condition was that anyway, so it was 3 years after. We don't have any reason to believe this has any relationship to the CUP, because the CUP is for parking, and parking is not referenced anywhere in here. And the covenant on its face says, in return for omitting fire resistive wall construction.
Correct. So
Yeah.
that's my question. So the whole thing relates to the firewall doesn't tie any lot to another one as parking.
You are correct.
So no connection of any parcel as serving specifically as parking lot to other parcel.
You are correct.
Okay, so the three APNs on, I want to make sure that it's the same thing for the three APNs on Empire. The four lots 37, 38, 39, 40, which is three APNs. Lot 40 is the corner lot, which is a vacant lot right now being used as the parking. But that didn't even have to serve as parking. They were using it as a parking, but it wasn't specifically a parking attached to the two other APNs. Over time, they've used it as parking lot.
You are correct. That could be concluded from that.
And then in 2001, another covenant, Exhibit E32 of the Exhibit E book, Covenant 02-0312753, renews the same agreement, removing Lot 41. So whatever the content of the firewall, which is logically correct, the way it was recorded in 2001, because it was all about the firewall. I just want to confirm that my understanding is correct. So it removes the Naomi lot in this CUP, this agreement. So it just the three APNs on Empire. And from that point on, whatever is the content, it specifically says here on E42, lots 37, 38, 39, 40 of tract 9443, the map book, the pages, and the information of the property. And the first line, it says that this covenant and agreement to hold property as one parcel for building requirement shall supersede and replace the same covenant on the property reference and documented 95-1812259. So from this point on, we don't even need to worry about Naomi parcel being included in any of the CUPs.
You are correct. Yeah.
So if they wanted to, if owners of Empire property wanted to develop the corner lot, which is lot 40, it didn't impact the parkings of the two other buildings. They had grandfathered parking situation. They could just develop that corner property. The same way that Naomi is developing, and they have their own parking. All they had to do to comply with development standards and come up with the parking requirement that they needed to do for the proposed project.
You are correct. The line of reasoning is correct. I will say this. I can't recall whether there's a specific parking covenant tying Lot 40, which is the corner property you're mentioning, to the rest of the Empire property. So in lieu of that not being in effect, you are correct. The property on the corner could be redeveloped, and it would not affect parking along Empire.
Yes, because my understanding is that whatever CUP was recorded back in '91 that was only dealing with firewall, then removed only Lot 41, which is the Naomi parcel, and the rest remains the same for the remaining parcels on Empire only, which if we say Naomi parcel didn't serve as the parking lot to Empire properties, then that corner lot itself didn't serve as a parking lot to two others. So it could be individually developed.
Yeah, we don't know the status of legal lot 40. There are many parking covenants along Empire. In fact, I had to go, when we were looking at this at the request of the appellant, we went through a lot of covenants. I came across all my kids' castle covenants because I remembered Mel Burney. I remembered covenants on Empire. You know, they're all the 2,700, 2,500, all those blocks. The parking is very convoluted out there. So there's no question in my mind where we've required additional parking. We have used covenants, and there are several covenants tying many of those parcels that appear to be vacant in the R4 zone there are covenants, and we've even swapped out covenants over the last 10 or 15 years. No covenant was ever required for Lot 41, 2215 Naomi. But there are many out there. So it's a little bit of a stretch to say that these properties could be independently developed at any time without impact on parking, because there is a delicate balance out there. And 1928 Jewelry's own operations, if they're still operating, had covenants across parking for their own employees' parking. So this is actually very confusing research, because there are covenants out there, and still today there are covenants out there for parking.
So the covenant is between the property owners and city, or?
So in all of these covenants, you have seen many of them for different businesses that needed off-site parking, and there are a great many of them in Magnolia Park. One of the churches there has covenants on individual spaces for daytime operation. What happens is the covenant is between the business owner and the owner of the remote parking, and the city is a third-party beneficiary with the right to enforce, to make sure that the parking is made available and that the parties maintain their obligations, and so that they're not double counting parking as well. And in that analysis, staff brings to the planning board parking counts, how much parking is needed for the business that has surplus, and how much parking is available for off-site. So any business that would come in, any new business, the first thing they would do is show staff whether or not they could meet current parking requirements. And then if they needed additional parking, they would have to identify off-site parking generally within 300 or 400 feet.
It depends on the
within
type of
300
use.
feet, and then we would work out the parking from there. But it's entirely possible that a tenant could come in a building and not need additional parking. Again, as Mr. Atukinian indicated, we wouldn't know until a proposal was brought forth, and we looked at the proposed use, the square footage, the parking requirement, and what they had on site. So we can't really make a general statement, except in this case, we have been over this record, and we didn't decide that the memo in 2008 was incorrect. We looked, and as the appellant indicated, we produced a lot of documentation from the agency purchase and sale, from the conditional use permit, from these covenants, and we have found no requirement binding Lot 41 for anything other than complying with conditions of approval for a parking lot. Other than that, we have not found any city restriction on use of that property or tying it to another parcel for parking.
And the only thing, if I can add to that, is in the conditional use permit that was also part of the land sale agreement, when that was approved by the city, there's a lot of inference that, the intent was to do X and have a redevelopment of the site. But more often than not, on a conditional use permit, because you're basically at that point conditioning future development of that use, there's no reference that this CUP is being issued beyond the build out of a parking lot that would have a specific purpose or tie to another property and require a covenant, so that regardless of whether staff changes over 20 years or 30 years, that runs with the land and is recorded against the property. So there is no dirtying of the title or any condition that says, hey, by the way, when you sell this off, buyer beware, this is tied to the property. We do have other processes that the city attorney has mentioned where someone can seek out a shared parking agreement showing proof that they have surplus parking in this instance. But over this time frame, when it's been sitting vacant for 10 years as fenced off parking, it doesn't seem to have been an issue to the point of coming to the city and saying, hey, we want to put in new uses on our industrial zone property that the appellant has, and by the way, we're not being allowed to access the parking lot at the rear. I didn't see any record of that on file. So, just making that jump from, maybe we just, when the redevelopment agency did it, they didn't decide to take that right of first refusal to buy back the property and do something with it. The owners owned it for this period of time, and there's no condition tying the two properties together. Maybe that was an oversight at the time, But the fact of the matter is, we can only rely on what's in front of us, and the facts are, there is nothing tying the properties together.
Thank you. Any other questions for staff, the applicant, or the appellant?
I have more questions, so I want to make sure that I have a question for staff. So right now, we know that the original property owner, after purchase from redevelopment agency, sells the property in 2008 to one party, 3 parcels.
Just to clarify, the
The
property was
Empire.
originally sold in 2002.
2002, yes. So
and-
they could sell to 3 APNs, they could sell it to 3 different parties, but they sold all to one, and the buyer sold all to the appellant.
Just to clarify, the covenant from 2002 and 1995, they do place restrictions indicating that the properties could not be sold separately because there is that building type for building purposes. So the reason I believe that the covenant from 2002 came to be was because at that same time, shortly after, they ended up selling the property separately. So current day, if someone, just to answer your question, if someone wanted to come in and sell the properties along Empire separately, they would not be able to, given that there exists this covenant from 2002 that restricts that.
Thank you. I have. No, that answers my question. I have a question one more question for you. And the last conditional use permit is the one that's recorded in 2002.
The last
The
conditional
last
use
one.
permit was from 1991. In 2002, that is a covenant.
The covenant.
It's something recorded on title with the property.
So the one CUP and the covenant in 2002. One CUP in 92 and then the covenant in 2002.
Correct, that are related to linking and unlinking of properties.
I have no more questions.
Thank you.
Any other questions for staff or the applicant? Seeing none, I now declare the hearing closed and the planning board will now deliberate. What is the planning board's pleasure? Board Member Liu.
You know, I'm actually very sympathetic to both the applicant and the appellant in this case. I do think the records are confusing, and I don't think anybody was acting from I guess, completely disconnected misunderstanding of what the document said. However, I think that I'm in agreement with Chair Rosati in terms of the due diligence during the purchase in 2008, the resale of the properties, that the appellant needed to ensure that what they thought, based on the title reports that they received, was actually accurate. And it is up to you when you're purchasing property like that to ensure that it is accurate. I also feel that I understand that you're stating, or Ms. Thompson was stating, that you will be harmed if this application is approved, and there's no evidence of that at this point because you have not submitted anything in terms of the use of what you're going to be using that property for and the associated parking requirements for that. I also think that given the circumstance of just more housing that's needed, that these R4 zone properties should be developed, if they can be, into residential properties. So with that, I am in support of the Planning Department's recommendation to deny this appeal.
Thank you. Anyone else? Board Member Hadian?
I agree with Commissioner Liu, and there is a confusion in the conditional use permit. There's 2 parts to that, a physical and a legal part. The physical part was for the wall between 2 buildings, and the legal part included all parcels, which later clarified with the covenant removing the parcel on Naomi. And I looked at all the documents and exhibits. There might have been a vision by a redevelopment agency, but it never turned into a plan. So there is a long way from a vision to intention, decision, and then a final resolution. I don't see any, even not even a schematic design for a project on these parcels. And there has been change of ownership in 2001, and then 7 years after the parcels were purchased by the appellant. So I don't think that the Naomi parcel is related or has to serve in any sort for parking lot of the future development, if ever a development happens. And I agree with denying the appeal.
Thank you. Any other comments?
I'll go.
Board Member Atakanian?
There seems to be a twofold process here that's kind of like concurrently being presented, and they're independent, but they're also interdependent on one another. The property rights that the appellant feels that they have in the adjacent parking lot, absent any concrete, I guess, evidence other than just memoranda, opinions, does not materialize. So additionally, looking at the findings that we need to make as planning board members, the two findings that are listed on page 6 of the report can easily be made under the circumstances and the evidence or the information that's present here before us. As I alluded to earlier, the documentation and trying to decipher through all these different covenants and materials that have been recorded, perhaps this may not be the best venue to address those in terms of does it trump the right of the other property owner, the Naomi property owner, in developing their property, because somehow there's this right to use the land, neighboring land, for parking. So I'm having trouble reconciling these two ideas here together, because I think they're distinct. They're not. They are distinct, but they are kind of interrelated, as I said. So, but at the end, based on the information presented and the evidence that I've reviewed, and what we've heard here today from the city attorney, from the head of planning, and Mr. Villa here, it's. I would have to say that I would vote in denying the appeal and adopting the resolution as amended.
Anyone else? I can go if you like. First, let me just say thank you for everyone and their efforts on both sides. There's a lot of information here. To me, it was pretty clear. When you peel back this onion, I don't see anything that ties, into 2018, I don't see anything that ties that parking lot to Empire. But I go back to my opening comment, and just from the most basic example, if I have a client that says, I want that chandelier in that house, it better be in that purchase contract, because if not, I'm buying my client a chandelier. That's just the way it works in my business. So it's very unfortunate that if the appellant intention was to purchase this property with that parking lot or use of that lot and not have that language in a purchase contract, it's very unfortunate, because that was a very simple item to put on an addendum or in the body of the contract, and we wouldn't be here today. I think it's important that whenever you purchase anything from somebody, there should be a meeting of the minds. Both parties need to understand what it is they're buying, and that should be in a contract. And we may not be here today if that was done correctly. So I am going to agree with my fellow board members and staff's findings. Thank you. Board member, Vice Chair Eaton.
Thank you. I agree. I am sympathetic to both parties, and I understand how confusing it all is when you start going through all the documentation over the period of 40 years. But I agree with Chair Rosati. The onus does fall to the buyer, and you have to make sure that you're represented and that someone is looking out for your best interests and making sure that all the T's are crossed and all the I's are dotted. And yes, sometimes the city, it's difficult to keep on top of every single thing and to make sure that everything is filed correctly. But that's why you hire a good attorney or a good real estate agent to look out for your best interests. So I too am in agreement with the other board members, and I can find the findings to agree with staff to deny the appeal.
Anyone care to make the appropriate motion if there's no more discussion?
I'd move that we adopt the resolution of the Planning Board of the City of Burbank denying an appeal to the Community Development Director's approval of project number 16-003542 for a development review for the construction of 4 residential apartment units.
As amended.
As amended.
We have a motion.
I'll second.
We have a second. Any more discussion? Please, all in favor of the motion, please signify by saying aye.
Aye.
Aye. Against? And abstaining. Seeing none. Motion passes 5-0. Thank you. Moving on with our agenda, do we have any reports?
Chairperson, there are no reports.
No reports. Oral communication, limited to items on the planning board agenda, and comments are limited to 3 minutes. Do we have anyone here? Seeing none. Approval of the minutes, April 23rd, 2018. Have we had a chance to review those minutes?
Can I make a motion?
Please.
A motion to approve planning board minutes of April 23rd, 2018.
I second.
We have, it's been moved and seconded. All in favor, please say aye.
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 I abstain.
You're abstaining? We have 1 abstention. Items from the planning board. Planning board members may introduce new items for discussion, but no action may take place except to place it on a future agenda. Seeing none? None. City planner comments?
No comments.
No comments. Okay, so we're going to adjourn this meeting to June 25th, 2018 at 6 p.m. Thank you all for coming.